In this class, we would like to discuss about human rights and Indian judiciary. So, how far and into what extent Indian judiciary played or playing its vital role in determining the position of human rights in India. So this is one of the most important topic both in human rights, so also under Indian Constitution that we would like to discuss in this video. So in that context, we would like to start it from the very enforceability of international treaties and agreements which are signed by India or India as a signatory to those treaties. So, on the very role of Indian judiciary in safeguarding human rights, first we have discussed the learned views of the apex court on the position and status of human rights with reference to the provisions laid down in Part 3 and Part 4 of the Indian Constitution. At the second instance, the Supreme Court made a clear cut division among the fundamental rights in their scope and application in relation to citizens and non citizens. The above two observations made in numerous Supreme Court decisions were the reflections on how Indian judiciary reacted on the protection and promotion of international human rights in relation to the Constitution of India. The next important aspect on which the Indian judiciary expressed its far reaching conclusions are on their applicability and enforceability. On the question of their applicability and enforceability, the Supreme Court, in the very leading case, Birma versus State of Rajasthan in 1951, held that treaties which are part of international law do not form part of the law of the land unless expressly made so by the legislative authority. And in the second important leading case, and that is relating to Shiv Kumar Sharma and others versus Union of India in 1968, the Delhi High Court held that in India, treaties do not have force of law and consequently obligations arising therefrom will not be enforceable in municipal courts unless backed by legislation. And in connection to that, we will discuss one of the most important leading case, that is Magan Bhai Ishwar Bhai Patel versus Union of India in 1969. Justice J.C. Shah reaffirmed the above views as follows, that agreement and treaties are not by their own force binding upon Indian courts. The power to legislate in respect of treaties lies with the Parliament under entries 10 and 214 of list 1 of the 7th schedule. Then again this question arises in another important leading case, Jolly George Varghese versus Bank of Cochin in 1980. Supreme Court held that the positive commitment of the state parties to international covenant on civil and political rights ignites legislative action at home but does not automatically make the covenant enforceable as part of Indian judiciary. These above observations were modified later on to a great extent by some outstanding decisions of the apex court. So we'll discuss those leading cases. One is Civil Rights Vigilance Committee versus Union of India in 1983. So also the Gramophone Company of India versus Birendra Bahadur Pandey in 1984. The Supreme Court expressed that national courts will endorse international law but not if it conflicts with national law. National courts being organs of the state and not organs of international law must perforce apply national law if international law conflicts with it. And in another important leading case, that is ADM Jabalpur versus Srikant Shukla, the Supreme Court, and especially Justice H.R. Khanna held the opinion that Indian courts may apply customary rules of international law if they are not in conflict with rules of domestic law, and if it is otherwise, then the court shall give effect to municipal law, leaving aside their applicability and enforceability. The most vital question came before the Indian judiciary regarding the interpretation and determination of those rights in the Universal Declaration and international covenants with reference to fundamental rights provided in Part 3 of the Constitution. In this context, the views of Justice P. N. Bhagavati is most important as relating to the case of Maneka Gandhi versus Union of India in 1978, that which exactly provides the very concept of justice and how it could be implemented in relation to international provisions under those treaties and agreements and how they correlate with the fundamental rights, and in that connection he made the remedy for enforcement of the rights as under Article 18 of Universal Declaration of Human Rights of 1948, and in comparison to Article 32 of the Constitution is being given a status of fundamental right under Article 32 of the Constitution of India as constitutional remedy. And in connection to that, we would like to discuss important leading cases like Bombay Education Society and others versus State of Bombay in 1954, and also Kesavananda Bharati versus State of Kerala in 1973. So also another important leading case, that is Chairman Railway Board versus Chandrima Das in 2000. Supreme Court observed that the declaration has the international recognition as the moral code of conduct having been adopted by the General Assembly of the United Nations, and the principles thereof may have to be read, if need be, into the domestic jurisprudence. So now we'll go to the important aspects of human rights relating to its very interpretation. Why Indian judiciary, and that is relating to protection of life and personal liberty. And as it is found place in Article 33 of the Universal Declaration of Human Rights 1948, it also found incorporated under Clause 1 of Article 6 and 9 of the Covenant of Civil and Political Rights of 1966, and regarding that we found the very observation made by Justice P. N. Bhagavati in Maneka Gandhi versus Union of India in 1978, as he held that what is necessary to be seen is, and what is the test which must be applied, whether the right claimed by the petitioner is an integral part of a named fundamental right or partakes of the same basic nature and character as the named fundamental right, so that the exercise of such right is in relation and substantive, nothing but an instance of exercise of the named fundamental right. So, Indian judiciary has rightly enlarged the very scope and application of these rights found place in the Universal Declaration and the two international covenants, in spite of their not being specifically mentioned anywhere in Part 3 of the Constitution of India. And they are as follows. So, regarding the very protection of life and personal liberty, as we found that the very question that raised regarding civil and political rights of the Covenant of 1966 has been has been rightly given the status of fundamental right in Article 21 of the Indian Constitution. The Indian judiciary under Article 32 and Article 226 of the Constitution which provides the writ jurisdiction of the Supreme Court and the High Courts, and through also public interest litigations and social interest litigations in long run has enlarged the scope and application of the provisions contained in Article 21 so such an extent that it should be discussed under different heads, and they are as follows. So, in that connection, we'll go to those portions, and when we'll discuss those portions, we'll discuss some leading cases where Supreme Court exactly interpreted, expand the very application of those human rights that we found under the Universal Declaration of Human Rights, also under the covenants of 1966 relating to civil political rights, also social, economic, and cultural rights, and in that relation, we'll discuss one important leading case, and that is Hussainara versus Home Secretary of Bihar in 1979. Supreme Court held regarding granting bail to an accused. The court held that pre-trial release on personal bond should be allowed, and in another important leading case, Bina versus State of Bihar in 1983, Supreme Court held that imprisonment of a person is unconstitutional after that person is declared insane. And the next important leading case, that is MC Mehta versus Union of India in 1987, Supreme Court also observed similar in another important leading case, Subhas versus State of Bihar in 1991. It was observed that right to pollution free air, public health, and ecology fall within Article 21. And next important point, which was interpreted in regards to human rights by our apex court is Sukdas versus Arunachal Pradesh in 1986. An accused person is entitled to be afforded legal aid if he is too poor, was held in this particular leading case, Sukdas versus Arunachal Pradesh in 1986, and another important case relating to natural justice is Olga Tellis versus Bombay Municipal Corporation 1986, and Charanlal Sahu versus Union of India in 1990. Supreme Court held the very principle of natural justice in the context of Article 21, which found place also under Article 3 and 3 of Universal Declaration of Human Rights, and also in Article 6 and 9, Clause 1 of this Covenant on Civil and Political Rights of 1966. So, another aspect is relating to right to livelihood, and as it was interpreted by our apex court, is an integral facet of the right to life, and it was held in this important leading case, Narendra Kumar versus State of Haryana in 1994 by the Supreme Court. And now we'll go to another important concept which was interpreted by our apex court, and that is relating to speedy trial. So, as in the leading case, Matthew versus State of Bihar in 1984, so also in the leading case, Sila versus Union of India in 1986, the Supreme Court held that inordinate delay in bringing to trial of any accused and of the child offenders, it violates Article 21 of the Constitution, which is also reflects the provisions of Article 3 of Universal Declaration of Human Rights also. Clause 1 of Article 6 and 9 of the Covenant on Civil and Political Rights of 1966. So, also we would like to discuss some other important leading cases such as People's Union for Democratic Rights versus State of Bihar 1987, then M.K. Sharma versus Bharat Electronics Limited 1987, where the Supreme Court held that persons affected, injured, and killed on the actions following the state are entitled to compensation as it falls under human right as interpreted by our apex court in relation to Article 3 of Universal Declaration of Human Rights 1948, so also regarding Article 6(9) Clause 1 of the Covenant of Civil and Political Rights. And now we'll go to another important aspect that was also interpreted by our apex court, and it is relating to the most important leading case, Maneka Gandhi versus Union of India in 1978. The apex court declared that withholding a citizen's passport for an indefinite period of time is a violation of the right to life. And in now we'll go to the final aspects of human right, how it is reflected under the prison of the detainees, classification of prisoners, handcuffing, torture, wrongful detention, preventive detention, execution, public hanging, death sentence, and punishment for suicide. So, in that connection, we would like to discuss the first most important leading case, and that is relating to Sheila versus State of Maharashtra in 1983. So also Sunil Batra versus Delhi administration, and which was a case of 1980. So also Sher Singh versus State of Punjab in 1983, the apex court pronounced that an under trial or convicted prisoner cannot be subjected to a physical or mental restraint which constitutes human degradation, and prison restrictions amounting to torture is a violation of basic human rights. Handcuffing is permitted only in extraordinary circumstances, as it was observed by our Supreme Court in the important leading case Sunil versus State of Madhya Pradesh in 1990. As it was expressed, there should be a classification of prisoners on the basis of ordinary or dangerous prisoners under sentence of death. So, in that regard, it was decided by our apex court in that very important leading case, Charles Sobras versus Superintendent Tihar Jail, 1978. So, the apex court here held that there should be a classification of prisoners on the basis of ordinary or dangerous prisoners and prisoners under sentence of death. So, in our upcoming video, we'll discuss regarding those important leading cases decided by our apex court in relation to wrongful detention and preventive detention. And after completing wrongful detention and preventive detention, we'll go to execution, public hanging, death sentence, and punishment for suicide. And that we'll discuss in our upcoming videos. And as this very subject is most important and relevant in context to human rights vis-a-vis Indian judiciary. And this very topic is very important for both human rights also regarding Indian constitution.